Okay, so let's get going. Good morning, everyone. My name is Neil Smith. I am a partner and I head up the restructuring team at Mills and Reeve. I'm going to be presenting with my colleague Morgan Bowen, who is a senior associate in the team. And we're going to be talking today about the opportunities, or certainly maximising the opportunity of buying business and assets from an administrator. Whether you've done it before or whether you've not done it yet, but think it might be something that you'll be coming across. Before we get into the presentation itself, just to let you know that this is being recorded, and the recording and the presentation will be available as soon as it's ready to go out. Probably by the end of the week, we will circulate it to everyone who's signed up for this webinar. We have a Q&A box, so please feel free to put your questions in there. In light of the format, we'll pick those questions up at the end of the session. We're going to have about 10 minutes for that. So please ask us any questions you want. Any comments will be gratefully received. And as I say, we will endeavour to answer them at the end. As for those who have done these sessions previously, those have not, I will come back to this at the end, but we are always interested in your feedback, both in relation to this session and any other sessions you might be interested in. And as I say, you will have our contact details on the slides if you've got any follow-up questions after we've finished. So having dealt with the housekeeping, let's just summarise what we're going to talk about today. So I am going to just talk a bit about administration and pre-packs, which you might have heard about in the news. Which are pre-packaged administrations, and then talk about the opportunity in the current market regarding buying business and assets out of those processes. Morgan is going to then spend some time looking at more specifics of things that you need to be aware of in a standard administration, sale contracts, some of the tricks of the trade, and then I'm going to briefly finish off with some of the try-ons that you will see from administrators. We obviously act as both gamekeeper and poacher. The role will obviously depend on on which side of the divide you're coming from, but we know what is market standard and what administrators are entitled to ask for, and we also know what they are not entitled to ask for, but will probably ask for anyway, just in the hope that they can get away with it. So I'll just briefly deal with that at the end, and then, as I said, we will have some time for some questions. So this might be a recap, it might be something new, but I think it is important just to understand what administration is and what pre-packaged administrations are before we start talking about buying business and assets out of those processes. So you will have heard about, I'm sure, Body Shop recently going into administration. Yesterday's news on administration was Ted Baker. So, there is a reasonably strong flow of high-profile administrations that are happening, particularly in the retail sector at the moment, which I think is part of the economic picture, which I'll come back to, which presents the opportunity. But administration is the process that is used where there is a business to sell as a going concern. Debatable exactly what that going concern is, but unlike liquidation, it is not a shutdown scenario. The administrators will be looking to actually sell a business as a going concern to maximise value for creditors. So in itself, it's an insolvency process that creates a statutory moratorium which prevents creditors from enforcing their rights. And therefore, if the administrators decide to trade the business for any period of time, rather than selling it as a pre-pack, I'll come back to what that means in a minute, then they have protection that creditors can't actually enforce their rights of what they might be owed pre-administration. However, the directors' powers in most cases cease, so the administrators will replace the directors post-appointment and they will be responsible for running the company. The administrator has various powers to trade. As I said, they effectively step into the director's shoes. They can trade the company, they can realise the assets, they have to investigate the conduct of directors, and they may or may not decide to challenge transactions that have gone on before the company goes into administration. But the administrator owes a duty to all creditors, and as I say, that duty really is to maximise value for the business and assets, and to get the best price reasonably obtainable in the circumstances for the creditors. It's a process that can be started out of court by filing some forms by the company, its directors, or a secured creditor. Much rarer is a court application by creditors who say they're owed money. And that really brings us on to pre-packs, in that process has been around now for just over 20 years, whereby you can actually use a form filing system at court to put a company in administration. What that has led to is the development of the pre-pack, because that form filing process is a relatively quick process to be done. It doesn't actually require court hearing or the preparation of evidence, etc. So the pre-pack is effectively still a sale of the business and assets, but the timing has changed. So rather than the administrators being appointed and trading the business for a short period of time with a view to finding a purchaser, everything is basically moved forward. So the marketing of the business and assets actually takes place before the administrators are appointed. So the administrators don't have an official role. They are acting more as corporate finance advisors at that stage. But they market the business and assets. They find a purchaser. They enter into it so that they negotiate the documents, and all the documents are agreed, ready to go for completion. Then the administrator is appointed, and then they immediately, normally on the same day, possibly within hours of appointment, will sell the business and assets to the purchaser. So you are front-loading all the work. And the idea behind this is to preserve value by minimizing the publicity around failed business, and also to try and save costs. Because if the administrators are trading a business, for example, a retailer, Ted Baker, that's an expensive business. The administrator's got to oversee the day-to-day running of that business, which they are doing at an hourly rate. And someone's got to fund that, most probably. And to the extent that the administrators actually make a loss during that trading period, that is an amount that has to come out before their costs. So they take a risk in that regard. So this is very much a well-trodden path now. It has been criticised over the years because the feeling is, particularly where empirical evidence has suggested that about 60% of businesses are sold to management by pre-pack, that the concern is that management simply buy the business and assets, walk away with the good bits, leave the creditors behind, and there are no consequences. So that's the public perception of pre-package administration. It's not necessarily the actual perception, but in certain circumstances, there is justification for criticism. The way that the regulators have responded to that is that now, if you are connected with the company, you as purchaser have to obtain a valuator's report. And that's worth bearing in mind if you are looking to buy, to go through a management buyout, that you will need an independent evaluator to effectively bless the transaction. From the administrator's point of view, there's something called a SIP-16 report, which is a regulatory requirement whereby they have to report to the creditors within 7 days of a pre-pack sale, explaining to them how they marketed it, how they chose the purchaser, what the price was, what was sold, etc. So there is some protection on both sides of the equation to militate against the concern that these are just dodgy transactions done without proper oversight. So that's kind of background on administration pre-packs, which are the processes that you're most likely going to see for the purposes of buying out rather than liquidation, which, as I say, is a breakup basis. The opportunity, therefore, I don't need to tell you about the current economic climate. Inflation is obviously down today, but cost of living is still weighing heavily, and you're seeing that with the recent failures in the retail sector that I've just talked about. So there are going to be businesses that are struggling. Administration numbers are on the increase. There's been lots of publicity about liquidation numbers going through the roof, but a lot of the time that's where there are no actually assets to sell. The opportunities tend to come more out of administration, and those numbers are on the increase. So there are businesses that are struggling. There will be competitors of your organisations that are struggling, and that may well create opportunities for you to buy business and assets, either with a view to setting up in new areas or buying complementary operations that will enable you to increase your business. And on the face of it, those are businesses in financial distress that can be picked up for a good price in the market. And therefore, I'm sure your organisations will be looking at those opportunities. The question for you as advisors within those organisations is how do you best secure that opportunity? And that's fundamentally what we're going to talk to you about today. You want to know, and hopefully we can help in that regard, as to how you might increase your chances of actually succeeding, because it's a competitive process. You'll be bidding against other parties, what that process is, and as part of the process, you need to understand what you're going to get, what you're not going to get, and what you're going to have to do to be successful in relation to your bid. So those are the kind of elements that we are going to go through today, and hopefully give you a bit of a competitive edge to your competitors when they are bidding for these businesses. So the first element of this is making the offer. I mean, fundamentally, there is no great science to putting in an offer to buy business assets. But when you are doing that from an administrator, there are certain things that you need to be aware of to give yourself the best chance of actually securing the opportunity. The process moves very quickly. To give you an idea, if a business approaches an insolvency practitioner with a view to going through a pre-pack sale, the insolvency practitioner is probably going to advise that they need 2 to 3 weeks to run what's called an accelerated M&A process, an AMA, where they will do limited marketing. They will open up their contact book and they will go out to parties to see whether they are interested in buying the business and assets. So we are talking weeks here. We are not talking months. So you need to be able to move quickly. There's going to be limited opportunity for due diligence within that time. So if you don't know the business at all, you're probably not going to be in an ideal situation. And therefore you've got to bear that in mind as an organisation. But normally what you do is, if you're going to have limited due diligence, you need to try and reflect that in the price, because that's the risk that you're taking. Having said that, you're only buying business and assets. You're not taking the liabilities. Those will be left behind in principle, although we'll come back. We're going to talk about some of the liabilities that you will have to take on as part of this process. The administrator is obviously interested in turning the assets into money, predominantly to pay their fees, which generally come out first. So they'll want to know that you're funded and that you can get hold of those funds quickly and can move within weeks, not months. As I've talked about, you might need to discount the price to reflect the risk. And you might be considering deferred consideration. As I say, administrators prefer money and prefer it up front. So if you can avoid deferred consideration, I think that will generally put you in a better position. If you want to go down the deferred consideration route, then it's likely that you're going to be asked to provide some kind of parent guarantee or security in relation to the deferred consideration, because normally the structure would be you would set up a new company to buy the business and assets. And therefore, if the new company is responsible for the payment of the deferred consideration, it is often the case that the business is bought and is not as successful as it could have been. And then the new company is then disputing whether it should be paying the deferred consideration. So from the administrator's point of view, they would like to avoid that if possible. But if you want to go down that road, then you're going to be talking about guarantees and security. But in relation to the offer, be clear what you want and what you don't. This may sound a bit perverse, but actually the administrator is generally looking to get as much of the business and assets away in one purchase rather than doing a number of different deals, because that increases time and costs. Clearly, if there are elements of business that can be sold for good value as independent operations, then the administrator will look at that. But generally, particularly in the SME sector, the administrator is looking to sell the business and asset lock, stock and barrel. And therefore, if you're prepared to take it all on, that may well put you in a better position than someone who is looking to break it up and only take certain elements of it. That's a general view, but it's worth bearing in mind. Some things that you need to be aware of. So the administrators or actors agent, they will exclude personal liability. Don't bother arguing about that. You won't get anywhere. And if you're not prepared to accept that up front, then I guess the question is whether you want to proceed with the transactions. You won't get any warranties or indemnities, and the administrator will probably seek some indemnities from you. They'll only sell whatever right, title and interest the company has in the business and assets. So Morgan's going to talk about ROT and third-party items, etc. You're taking a risk there, and you need to reflect that in the price. We can help in relation to the indemnities, because obviously when in-house lawyers hear indemnities, their blood starts to run cold. They are standard in these situations, but they can be watered down, and we can help with that in relation to what you would be indemnifying and what you would be. So I'm now going to pass over to Morgan. He's going to talk a bit more specifically about some of the elements that you'll come across in relation to the business and asset purchase. So over to you, Morgan.
Thanks, Neil. Yeah, so just discussing, first of all, the premises from which the trading is done. The lease will usually require the landlord's consent for assignment, and consent may not be able to be obtained before sale, usually isn't. If the premises are needed, pending receipt of the landlord consent, the seller usually provides an occupational license, which is effectively a bare license, and the administrator usually requires wide-ranging indemnities in relation to the occupation. The administrator will also require the full amount of the lease to be paid during the period of the occupation, because this effectively, so where premises are being used during an administration, the lease cost for the period of the use is payable as an expense of the administration, i.e. with higher priority than the unsecured creditors. And so an administrator will insist that throughout your period of occupation as a licensee, that you pay the rent in full for that period of occupation. The buyer then needs to prepare to move out or to negotiate an assignment with the landlord in relation to the lease if they wish to stay. If the landlord wants them out, then usually it's going to be difficult for them to avoid that. There is a moratorium preventing the landlord from retaking premises, which basically prevents them from forfeiting themselves and would require them to go to court. But in the usual scenario, in particular where there's no deferred consideration payable under the sale, post the completion of the pre-pack and post the sale away of the assets, and once the purchaser is in the premises under the license, if the landlord wants to get the premises back, then usually they can, and the court would usually lift the moratorium to allow them to do that, to basically effect forfeiture. So it becomes a negotiation with the landlord at that point. Turning to the next slide, we have here purchase price and tax. So the buyer will not normally care about how the purchase price is apportioned between the various assets, but the administrator will want to apportion value as between fixed charge assets and floating charge assets, as this determines where the proceeds flow and also determines how they get paid, because they get paid out of floating charge assets and not out of fixed charge assets. For a floating charge, no requirement for consent from the chargee is required for a sale by an administrator. Effectively, the charge is overreached, and the chargee's charge attaches to the proceeds of sale. For a fixed charge, where that's a fixed charge asset, where that's being sold, the consent of the chargee or the court is required. In any event, the buyer ordinarily requires a release by the chargee, even for floating charge assets, just in case some assets have been miscategorized as floating charge assets when they're in fact fixed charge assets. So normally it's usual where there's a charge situation for the chargee, for a negotiation with the chargee in advance of the pre-pack to get their release for all assets. Generally, assets sold on a going concern basis are not subject to VAT. The sale documents usually provide that all consideration is exclusive of VAT, and that if the seller becomes obliged to pay VAT, then the buyer will account for it and provide a VAT invoice. Stamp duty is payable on transfers of stock, shares, and certain interests in partnerships. But obviously the purchase of the assets themselves out of the administration, if the company doesn't have shares in other companies, those assets aren't necessarily subject to stamp duty unless they involve land. It would only be the shareholdings of the company and administration if they have shareholdings and where they're being sold. And then obviously stamp duty, land tax is payable on transactions involving UK land and buildings and in certain partnership transactions. Tax input is often needed on these issues as they can lead to they can lead to considerable negotiation between the parties, and it's usual to get a bespoke tax input on that. If we could turn to the next slide. So here we have the slide on business name. So the buyer obviously can buy the business name if they want. But if they are doing this, they need to be aware of Section 216 of the Insolvency Act. So this act basically says that where a person who was a director of a company before it entered liquidation, that person is prohibited from acting of a new company with the same or a similar name. It's basically known as the Phoenix trading provisions. If they do so, they will be criminally liable and will become personally liable for the new company's debts. Now, Section 216 does not apply where the company went into administration, but companies that go into administration very often enter liquidation at a later date, so it remains a live issue on a pre-pack sale. There are 3 exceptions. Where the business is purchased through admin or liquidation, and the director notifies the creditors of the insolvent company and puts a notice in the Gazette. That's one exception. The second exception is where the second company was known by the prohibited name for at least 12 months before the insolvent company went into liquidation and is not dormant in that 12-month period. That's a second exception. And the third exception is with leave of the court. So be careful where there's a management buyout of an existing company, because and you intend to use the business name, as that can lead to Section 216 issues. Turning to the next slide, we have retention of title and third-party items. The administrator, as Neil was discussing earlier, only sells whatever right, title, and interest the company and administration has in the business and assets, and will invariably exclude any warranties as to title and things like that. So those are non-negotiable. The administrator will usually insist on a clause passing commercial risk for retention of title and third-party claims onto the buyer, and a further clause passing only possession of ROT and third-party goods to the buyer. So effectively, they're not passing title to them; they're just passing possession of them. And then if there are ROT or third-party claims, it's then for the buyer to resolve those issues with the ROT or third-party claimant, and there's no recourse to the seller or the administrator. The administrator also usually insists on wide-ranging indemnities to protect from ROT and third-party claims, whereas the buyer will usually insist on a transference clause, transferring title to ROT and third-party property where the ROT or third-party claim is not valid or enforceable, or where an agreement is reached with the ROT or third-party claimant to release the rights. So effectively requiring the seller then to use reasonable endeavors to transfer the asset. Turning to the next slide, we have contracts and debts. Now, the buyer needs to think about what contracts it wants to take over. And as Neil said, there's usually a very limited period of due diligence in relation to them, but they will need to give thought to what contracts they want to take. Usually the benefit of contracts can be assigned unless there's a prohibition in them under the contract. but the burden of a contract cannot be assigned without the consent of the contractual counterparty. So if the company in administration is required to perform certain things under the contract, i.e. is under a burden under the contract, that burden can't be transferred to the buyer without the consent of the contractual counterparty. Effectively, what was required there is a novation, a sort of three-pronged agreement. So it's usual to have clauses saying, effectively the buyer will use reasonable endeavors to procure novation. The seller will execute novation agreements if a novation is achieved with a counterparty, but only on terms that the seller is discharged from liability. Where no novation can be agreed, the buyer sometimes agrees to act as the seller's subcontractor. And there is usually a buyer indemnity for all claims, so a buyer indemnity to the seller for all claims arising out of matters occurring after the transfer, but not before. There's often then issues around prepayments, where payments have been made in advance of the pre-pack sale and who is to benefit from those. Second question, does the buyer want the book debts? If not, it may still be sensible for the buyer to act as agent of the seller for collection purposes. If the book debt team has gone to the buyer, as the buyer's team will know more about recoverability. In this event, it is usual for a collection fee to be negotiated. If we could turn to the next slide. So this is on IPR, intellectual property rights and data protection. Sorry, we're actually on employees, TP and pensions. I do apologize. Just bear with me 1 second. So yeah, just on this. So 3 specific rules operate where there's a transfer outside of an insolvency context. The contracts of employment of the employees being sold are deemed to be transferred automatically from the seller to the buyer without variation. The employees are protected against any dismissal unless there's an economic, technical, or organizational reason for the dismissal, an ETO reason. And there's a duty to consult with employee representatives on the transfer. Some of these 2P protections are relaxed in an insolvency scenario, but a distinction for this purpose is drawn between liquidation and administration. The relaxation of the 2P protections is much more limited in the case of a administration than in the case of a liquidation. So in a liquidation, employees do not automatically transfer, and any dismissals will not be automatically unfair. In an administration, some pre-existing debts owed to the employees do not transfer, and they're taken over by the Redundancy Payments Office. And variations to employment contracts are permitted where the sole or principal reason for the variation is the transfer itself or a reason connected to it, and it is an ETO, an economic, technical, or organizational reason. But the remainder of the 2P rules apply in an administration, and this means that employees that have been dismissed by reason of the transfer where there was not an ETO reason are automatically unfairly dismissed, with the effect that in such cases the RPS pays the employees wage arrears and holiday pay, but nothing else. So payment in lieu of notice and redundancy would transfer to the buyer, and whether or not the buyer is liable for breach of contract would be a matter for the relevant employment tribunal. Where the dismissal is by reason of the transfer and not for an ETO reason is a question of fact, but there is case law to the effect that dismissals for the purpose of making a business more attractive to a potential purchaser is not an ETO reason, even where the potential buyer has not yet been identified. So there is a very clear risk in an employee transfer scenario, in an administration pre-pack scenario, of effectively being liable for all the employee liabilities, with the exception of certain liabilities that stay with the RPO. Usual clauses, parties agree that the transaction constitutes a 2P transfer, so that employee liabilities transfer to the buyer. The administrators usually insist on a clause to the effect that they have no liability for the employees, and the buyer should try to get this limited to liabilities arising after the transfer time if possible. There's usually a negotiation over that. The administrator will also usually insist on the buyer providing an indemnity in respect of any claims made later by the employees and any 2P claim in relation to failure to consult. On pensions, defined benefit pension schemes are in deficit or often a major issue in insolvencies. Occupational pension rights are excluded from transferring under 2P. The pension scheme should remain with the seller and go into the PPF. Clawback risk. So contribution notices and financial support directives, usually they wouldn't bind on a buyer through a pre-pack, but there might be a risk of a claim where shareholdings have been purchased by through the pre-pack. So where the company administration owned had shares in other companies, and then the shares were sold to the buyer through the pre-pack. Pensions regulator and PPF usually seek anti-embarrassment shareholdings in any new entity if their approval is sought. If it is not, there is a risk of clawback claims. This usually, as I say, doesn't affect the buyer, but it may affect the seller. And so the administrator may insist on seeking approval from the pensions regulator. If they do, the usual anti-embarrassment shareholding sought are 10% for an unconnected buyer and 33% for a connected buyer. And then if we move to the next slide, which I'm hoping is on IPR and data protection. Yes, sorry about that. Getting my slides mixed up. So intellectual property rights definition is usually very wide. But if the buyer knows they're getting something specific, that should be precisely defined in a schedule to the agreement. And likely they should also seek separate assignments and or licenses in relation to specific IPR. And if the buyer and if the seller is licensing the IPR out or is it themselves taking the benefit of the license, those license agreements should be reviewed to see if there are any breaches and what can be done to transfer them effectively. There would also be it's usual to get clauses seeking assistance from the buyer with registration for the seller, with any registration requirements and assistance with any innovation requirements with any contractual counterparty. And it quite often you'll seek a confirmation that no transfer, assignment, or charge of IPR has been done. But that is usually pushed back by the administrator, but you do see that. Data protection advice on customer lists. So if you're buying customer lists, if that's a very important part of the sale, data protection advice may be needed around that and the breaches. The administrator will almost invariably insist on indemnity protection against data protection breaches. And there are ways in which those types of clauses can be negotiated, and specific data protection advice is usually needed on those, in particular if you're dealing with a business with extensive customer lists, and that's a very important part of the sale. So I think I'll hand back to Neil now.
Thanks, Morgan. Just briefly finishing off, as I said I would, regarding try-ons, and as I say, we act for administrators, so we know what the administrators will start out looking for, and we'll also know what they will die in a ditch about and what they won't. The things that very much will be asked for, but are not market standard and can be pushed back. Full indemnity protection for the seller. As I said at the beginning, it's market standard to limit down those indemnities, and if you are getting legal advice, then you should expect your solicitors to be pushing for those indemnities to be reduced down. But again, if you're not instructing a firm that knows and has bought from administrators before, then you run the risk that they're not picking up that point. Administrators often in their precedent include specifically that any amounts falling due under the contract are unsecured, and in a variety of cases that effectively means that those claims are going to be worth nothing. The legal position is if you enter into a contract with a company in administration, then any liabilities coming out of that contract will constitute administration expenses which are paid out before the administrator's fees and therefore have a fair chance of being recovered. There is likely to be a negotiation as to what amounts should constitute administration expenses and what shouldn't, but certainly you shouldn't be agreeing to an overall blanket unsecured liability position, because that will make any claims worthless. And if the administrator is actually agreeing to do something as part of the transaction and loss arises, then you obviously want the ability to recover that loss rather than just unsecured creditors. In addition to the indemnity, which is market standard, the administrators often will ask for waiver of any claims you could possibly dream of, and that's something that can be pushed back on. Just because personal liability has been excluded doesn't necessarily mean that claims should be waived. And often, successors point protection for replacement of administrators is probably fine, because administrators do change, they lose firms, etc. But subsequently appointed liquidators could be anyone. It could be the same individuals in a different function. It could be someone completely different, and that's far too wide and generally should be pushed back on. So that's a canter through some of the issues that you will see on buying business and assets. Just as I said, we've got some time for questions, and I'm going to lump them together, but if there are any other questions that's going through, then please shoot them into the box. If you give us your details, then obviously we can follow up, but I'm not going to name anyone on screen. First question is will the administrator give any warranties if requested by the buyer? The general answer to that is no. You may get some standard warranties around authority, but it is likely that the administrator's position is it's very much sold as seen, and therefore as purchaser you are taking the risk, and as I said earlier, that really needs to be reflected in the price. If the administrator is agreeing to do something specific in relation to your transaction, then you may well be entitled to and may well be asking for warranties. But a general starting position for the administrator is going to be, I'm not going to give you a warranty. That is not personal, it's just standard. You just need to be aware of that. And as I say, your best protection for that risk is to reflect it in the price. And I was going to come on to this anyway, but a second question. So in terms of novation contracts, I have seen a deed where the administrators executed underhand instead of by deed. Is that standard practice? We would usually require the administrators to execute under deed, but where you are entering into a contract, the administrators, as I said earlier, are acting in lieu of the directors. So, if a contract is being entered into and signed in accordance with the company's articles, constitution in a certain way, then the administrators can proceed on that basis as well. But normally, we would require the documents to be signed by deed and witnessed. That would be our usual recommendation. Question on due diligence. Is there any due diligence the buyer should do in the time? It is standard when the insolvency practitioner is running the accelerated M&A process for them to set up a data room. So there will be certain basic information that is put in that data room for buyer's information. So it is not the case necessarily that there will be no information available in relation to the business, but that information is likely to be limited. Obviously, buyers typically they sign an NDA first, so they get access to the data room to look at the details in relation to the company that their business and assets they're thinking of buying, and they can ask questions. I think we just need to accept that, certainly from the administrator's or the proposed administrator's point of view, they're likely to have very limited information, and that will be their starting point. You may or may not be able to get management to assist. You can certainly ask the questions. I just think you need to be aware that you may not necessarily get the answers or the answers that you want, and you won't have the time to hold out for those answers before you need to make a decision about whether you're going to make an offer for the purposes of buying the business and assets. We've talked about novation. A few questions around that point in relation to the fact that there are likely to be key contracting parties that you would want to have conversations with to understand whether they would come across as part of the business and asset purchase. Again, there's no hard and fast rules here, but it's very unlikely that the administrator or the proposed administrators in the company are going to let you talk to those parties before you've had an offer accepted, because you may have a number of competing parties and you don't want more going and talking to key contractual parties at that stage, particularly where the company may or may not be in administration and may or may also filed what's called a notice of intention, which would create a moratorium. If there isn't a moratorium, obviously the risk on the company side is that contracting party knows nothing about the difficulties and then seeks to enforce their rights, possibly terminating the contract. So what we would usually recommend is make the offer and then in parallel with negotiating the sale contract. And typically there's about a week before offer and completion. So in that time, then contacting the contractual parties and getting a feel for whether they will novate. Normally, you won't have that in the bag. You won't have an agreement pre-completion. You've got to take the risk that you can get it done post-completion, but at least you will have an idea. And ultimately, if you don't think the contracting parties are prepared to novate, then you're subject to contract up until completion. Generally, you will simultaneously exchange and complete. There won't be an exchange followed by completion at a later date. And if you have to pull out because you just don't think the business is viable enough, then you will have that opportunity. So that's generally how we would recommend approaching novation. Just not able to get through all the questions, but I'll just deal with one more in the time that we've got. We often get asked about value. We are not valuers. It is likely that the proposed administrators will obtain a valuation, and for their purposes in establishing whether they are getting best price reasonably obtainable. They won't generally let you see that valuation. And so it is a very inexact science. But I would say that generally, in my experience, you are talking about offers in the hundreds of thousands rather than millions. That will depend on the nature of the business, obviously, but to give you a rough guide. And often, if you are the sole interested party or the sole seriously interested party, you may get into a reverse engineering exercise whereby the value of the business might actually be less than the total cost of the administration. And therefore, the value is worked out more on what it's going to cost to do the administration rather than what the actual assets might be worth. Again, I think it is, there is an advantage in getting your offer accepted and getting your feet under the table and then continuing to push with questions and talking to interested parties to evaluate whether this business is a viable purchase or not. And so that is often the best tactic in trying to assess true value. As I said, you're subject to contract and therefore may or may not have the ability to move the value. We are at the end of our time. So in an effort to get you away on time, I haven't managed to cover all the questions, but hopefully that has been an interesting insight into how you can hopefully make the most of the opportunity of buying a business out of administration. Please let us have your feedback. The feedback forms will come around with slides and the recording. We'd like to know about that. We'd like to know about what else you want to know. And there is a survey at the end of this webinar. So if you could complete that, then that would be much appreciated. The next webinar for next month is in relation to navigating generative AI, which is obviously a very hot topic in the legal industry at the moment. So hopefully you can join us where Simon Thompson will be talking about those matters. Okay, we are on time. I will let you get on with your days, but thank you very much for all your questions and your time, and have a good day. Thank you very much.
Thanks so much, guys. Goodbye.